Before the court, numbers 3 and 4 on today's list. Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43. Mr. Kearney is present and represented by Attorney Tim Bradel, who is present in court, and Attorney Mark Vetero, who is present via Zoom. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. Matters on for various motion hearings. If the parties could please identify themselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Okay,
Hello, Your Honor. Timothy Bradel on behalf of Aidan Kearney,
already.
person for the record.
Okay. Mr. Kearney's here.
And
Good afternoon. And Mr. Bedrow, you're on Zoom, are you?
I am, yes, Your Honor. Good afternoon.
All right. Before we call this case, this is going to take a little bit of time. Are there any other cases that need to be heard today? Nothing else. Okay. All right. Is there a natural order to things here?
My thought, thank you very much, counsel. My thought, Judge, was that I filed a notice of interlocutory appeal on Your Honor's ruling on the suppression, and I filed in connection with that a motion to stay the Taint team procedure until the single justice can either accept the petition, deny the petition, refer it to the appeals court or the full bench, which I think would probably take, into about mid-January, Your Honor. And for the reasons that I cite therein, and I
Let me read it.
Sure.
Hand it to me just a minute ago.
And on that point, Judge, I don't expect.
Let me
my
just read
brother
it. Let me just read it because I'm going to.
Yeah.
Okay. Have you had a chance to take a look at this, Mr. Cosgrove?
I have it.
Okay. Is there an opposition to it?
Yes.
Mr. Bradel, I hear you on it.
Thank you very much, Your Honor. So, Judge, it's really just the balance of harms issue in your discretion that, the government is poised to further search through Mr. Kearney's remaining devices, wherever they haven't searched yet. And, there's very important things in there. There's about, Mr. Kearney has about 5 or 6 other matters in which he has attorney-client privilege communications in his devices. He has journalist source material. That's really the reason.
But I see, what the next step is to get a Taint team protocol. That's what we're going to do today.
Sure.
Either you have an agreement or you don't have it, and I'm going to enter an order.
Yep.
Okay. I haven't
We did
seen
talk
any.
about that.
I haven't seen any opposition from you to the Taint team protocol proposed by the Commonwealth.
Correct.
So I assume there's no opposition and I should enter it. With respect to this motion to stay, all you're doing is seeking to stay the Taint team,
Correct.
right? I see no reason to do that because the DA is insulated from receiving any of that. You want to go up, you think you have a meritorious appeal, you'll take your crack at it. And if it gets stayed by the appeals court or a single justice, it gets stayed. But you're no more harmed by starting on the Taint team process than not.
I do have a response to that aspect of it, Your Honor, is that, there's some very sensitive journalist source material in these devices. We're not sure, we don't know, we don't have an inventory of what they've searched, what they haven't. But, my client receives source material from many people, and he is.
The question is, how are you harmed by starting on the Taint team protocol, which is to have the devices searched for privileged material, and you'll give a list of keywords that have to be searched, and there'll be essentially 2 people that'll have access to the devices and the data. before you do.
No one, including a Taint team reviewer, should have access to a journalist's confidential sources, Your Honor. That's our position. These people are civilians, police officers who volunteer information, whistleblowers who give my client information about all sorts of people. And in this particular case, Judge, there's a very important issue at stake, which is that the very
That's what the Taint team is for. That's what the Taint team is for. The Taint team is going to review these devices for that kind of information. Now, there's a question as to whether the Taint team is set up for anything other than the attorney-client privilege, but you're going to give a list of names and sources or other things that you want segregated from the Commonwealth. That is to say, the Commonwealth can't see, and that process ought to begin, it seems to me, and there's no harm in beginning that process. Certainly no harm to your client or sources.
Well, Judge, the harm is that people have, given Mr. Kearney very sensitive information. Here's the important part about these very same investigators that are going to look at his phone, that are going to try to look at his phone. Yes.
The proposal is retired Judge Macy and forget the other person, a person named Verino. I assume that neither one of them are involved in this investigation. Is that correct? So this material is not going to fall into the hands of the very police officers that you're talking about. It's going to go to the Taint team initially, and it's going to be controlled. Taint team is going to be controlled by the court, and you're at some point going to have to review the work of the Taint team.
The problem is there's never been a judicial review of the journalist issue. There's never been a pronouncement from the appellate court.
So if there is any journalist issue, if preventive medicine's Taint team protocol covers First Amendment sources, we're going to have to tee that up. That is to say, it's going to have to go to a Taint team. You're going to have to specify who the sources are, whatever else, whatever keyword we have to figure out. That's going to come before the court. The court's going to have to make a determination about whether that should or shouldn't apply. Okay, right now, you're proposing to have me adjudicate something in a vacuum. I have no idea if there's source material on there. I have no idea if there's anything on there. Okay, and
Mr. Kearney has provided in past pleadings, Your Honor, an affidavit to that effect, and I can get that to you. It's probably buried, 20 documents back, but I'll get that to you. But there is an affidavit in the court's record about what's on these phones. And just while I'm on that point, Judge, we have asked for the phones back a number of times, and I can show you that too. But I don't think it's determinative in your court's ruling, about the suppression. But the idea here, Judge, is that, well, first of all, I appreciate you narrowing the issue to just who gets to see these source materials. Should a Taint team person see such sensitive things? Let's say a police officer that works with these investigators that are chomping at the bit to get into my client's phones. Let's say that investigator works with these people and is a whistleblower about certain misconduct that may or may not have been reported on yet, or it may have been reported by Mr. Kearney already in a confidential way. It may be a future story. Whether that should be looked at by anyone else hasn't been litigated, Your Honor. And that's the part of this that's so important, that needs a full hearing. It needs review by an appellate court, that that these source materials are dangerous and sacrosanct. And Massachusetts, as I know you know, is kind of behind the 8 ball on protecting journalist material. There's no statute. There's meager case law that I gave you last time. It's nonetheless, the First Amendment protects journalists. The Pentagon Papers case, Your Honor, protects journalists. There's sort of a piecemeal quilt of protections. And I think it's about time, and this may be the case, where the SJC, the single justice, or the full bench can say journalist materials need to be protected, Your Honor. We know that attorney-client things are not quite as sensitive in terms of somebody putting their career on the line, putting their life on the line to give information to a journalist.
We don't know that for a second.
Well, it could go either way. That's really more to the point, isn't it? That we have to figure it out. And, you know, people risk their jobs, people risk everything to blow the whistle on corruption. And that's what Mr. Kearney receives time and again. And his track record, you know, you may not like it from one perspective, but from another perspective, I know you're a fan of the First Amendment, and Mr. Kearney has an unmatched track record of scoops, of revelations, of uncovering corruption. That's why he's sitting here, Your Honor. So these are incredibly important issues that to ask for 30 days to have a single justice evaluate the same arguments I'm making to Your Honor is really not a ton to ask. You know, it's just some time to allow me to get the brief to the single justice, let my brother respond, and let's see if we can actually generate some important case law, some appellate precedent that can give us some guidance on what to do in the situation and to give some protection to journalists.
All right, let me hear from Mr. Cosgrove.
Just two brief comments. One is it may be that an affidavit setting forth all of this has been filed somewhere and I missed it. But my memory fails me as to seeing this so far as I recall. These have just been representations of counsel who I assume have not been through Mr. Kearney's materials. The other thing I would say is this is not a promising interlocutory appeal by the usual standards. One of the most significant factors is whether any harm can be remedied in the ordinary course of appeal. And of course, we know that if there's a failure to suppress something that should be suppressed, that's classically something that can be remedied in the ordinary course of appeal. So I don't think, candidly, that Mr. Bradle's chances of an interlocutory appeal are particularly good. And for the reasons Your Honor has articulated, I don't see that we lose anything by going forward on the Taint protocol, because we're talking about, frankly, a several-month process before anything is even turned over to the Commonwealth. I would suggest that Your Honor deny the motion. I'm happy to hold off for 4 or 5 days. If Mr. Bradle wants to appeal Your Honor's denial of his motion to stay to the single justice, to give you time to do that. But I think the proper action is to deny the motion.
For the reasons stated previously, I agree, and I'm going to deny the motion for further, to stay further search pending interlocutory appeal.
Yeah, just so I have it right, your position, you're holding, your fact-finding, Judge, is that those source materials and attorney-client privilege materials will be protected through the Taint team protocol.
We're about to get to the Taint team protocol.
Okay,
We're about to get to it.
all right.
I endorsed the Commonwealth's revised proposal for examination of digital materials, docket number 53 in docket 23313, back at the beginning of this month, that the court will take up this motion at the hearing today, 12/17. The parties will discuss the proposed protocol in an effort to resolve any differences before the hearing. Any opposition to this revised protocol shall be filed by December 13th. Did you file an opposition?
No, Your Honor.
Okay, so I should adopt this proposed protocol?
Your Honor, we have,
Did you discuss it with Mr. Cosgrove
we did, excuse me, sorry, we did,
after the last hearing?
yes.
Okay,
So we talked about, or I raised 3 issues, Judge, that are not covered by the government's proposal. The first was that whether other privileges would be honored by the Taint team through keyword searches, and I think they will do that if we're giving keywords to them that involve journalist privileges and so on and so forth. Obviously, it's impossible to give keywords about source materials without ringing the bell. So, you know,
The keywords are disclosed to the court, right? And the court's going to provide them to the Taint team under this protocol.
right. So you can see how problematic it is that there be generated a list of keywords that are potentially related to source material. So, you know, that's one of the issues that we object to. The second issue that we want to deal with is that the government is specifically excluding from potential search terms any communications relative to the attorneys in the Karen Reed case. And we would object to that, Judge.
Because there's an attorney-client privilege between the attorneys and Mr. Kearney?
Well, there's a joint defense issue, Your Honor, that they're both.
So it would predate any jeopardy to Mr. Kearney. So communications with them predating any jeopardy to Mr. Kearney would not be covered by a joint defense. It would only be after Mr. Kearney was charged that there would possibly be a joint defense,
Well,
right?
it's a little more complicated because we know that he was under investigation along with Ms. Reed without any resultant charges. So we would contend that does fall under the umbrella.
Hang on one second. Okay, go ahead.
We would just contend, Judge, that the Karen Reed issue is a live question, whether or not there's a joint defense umbrella on that.
Do you have a joint defense agreement?
We don't have an agreement, but there's an implicit, there's been an ongoing, long-term implicit mutual assistance and mutual defense that I myself have been a part of for a long time, and Attorney Bedro has as well. And it's an issue that is not able to be worked out.
I really have no idea what that is. That means, are you asking me to make any particular, let me ask you, on the first issue, are you asking to make any changes whatsoever to the proposed protocol? I'm looking at the motion, which is docket number 53, indented paragraphs numbered 1 through 10 on pages 4 to 8 of that document.
Judge, what I would ask, Your Honor, is that you give us a little more time.
No, today is the day. Today, we're doing the Taint team. I specifically ordered it 2 weeks ago. If you wanted to submit an opposition, you could. You didn't. So I'm going to act on this now, and I'm bending over backwards to accommodate you here, not having filed an opposition, and I'm hearing you on any potential changes that you are suggesting need to be made to this protocol.
Well,
But
Judge,
I'm not hearing any specific ones,
we filed a motion to stay.
and I denied that.
Right.
So the next
So
question is,
I am now asking for time to respond to some of the more detailed issues.
that's denied. Okay, I set a schedule for dealing with the protocol 2 weeks ago, and it was to do it today. So, hearing no specific proposed changes to this, I will adopt the proposed protocol. I'll need to get a copy of it in Word form so I can adapt it into an order. So if I can get docket number 53, maybe I already have it in Word form in some email someplace, but I'm going to need it
I'm sure I
in
can
Word
submit a
form.
copy to the
Okay.
clerk.
Okay. There was a motion to compel Rule 14 discovery that was filed by the defendant, and 2 weeks ago, I entered an order that required the parties to confer about that. and to let me know in writing by last Friday if there were particular requests that were sought. I don't believe I saw a letter requesting any additional discovery.
We have conferred on that,
Okay?
Your Honor. Two things. I did file a motion for a protective order with respect to some discovery that responsive to that I'm prepared to.
So I got the Commonwealth's notice of discovery on December 10.
Right.
And there was a motion for protective order regarding communication produced in the Commonwealth's notice of discovery of December 10. That's how it's captioned.
Yes.
And I signed that back on December 10.
Oh,
Is that what you're referring to? Maybe it wasn't docketed in the signed form. I
yes,
don't know.
I think it probably wasn't docketed. Or
Let me just give this to you and make sure this is the right document that you're thinking of.
it sounds like the right thing. Yes, thank you.
There is something docketed as docket number 55.
Did you receive a copy of this, Mr. Gill? I know you saw the original. Did you receive a copy of it endorsed?
No, I don't believe so.
All right, so you folks can take a copy of that today. We'll get a copy for you.
It's probably a flaw in the way the file that you use. So in any case, I'm going to turn all that material over to Mr. Brady.
Okay.
I'm aware that the court has executed the order. Thank you. There is additional discovery involved in terms of the search of the iCloud for the district attorney's records and search of some of the employees of the district attorney's office, which is in progress at the moment with Karen Reed team. I have conferred with them and will provide them with additional search terms that are specific to this case.
This is the so-called Proctor discovery?
Yes, and also some of the other offices that are involved. Most of the search terms will be identical to those that the Reed team is using because with one or two exceptions, the alleged victims on the indictments that are before Your Honor are the witnesses in the Reed case. So it comes out to the same thing, but there are a few additional names. I'm going to submit that. Once the search has been done, I will review all of the documents and turn over all the Rule 14 material to my brother. I expect that's going to take probably another 3 weeks.
Okay. And you have a date in January for another hearing
January
on
10th.
the issue with respect to Mr. Mello.
Yes.
Um,
And with respect to that, Your Honor, I have to tell the court that I don't think Mr. Mello's health is going to permit him to attend that hearing. So I don't know what Mr. Breda wants to do, whether he wants to try and go forward without Mr. Mello, whether he wants to get another date, or whether he wants to use it for some of these other issues that we've got.
Is this your motion, Mr. Bradel? I don't think I went back and read that motion. What are you seeking to do?
Yes, there's a motion to disqualify Mr. Mello for a host of reasons, Your Honor. And that's been pending for a long time. So
When did you file it?
9 months ago, 6 months ago.
Okay.
And then since
And
my
it's,
file.
and it's opposed?
Yes.
But Mr. Mello was not able to get here and is somehow impaired,
That's correct.
okay?
Since my
Do
original.
you
file-
expect him to try the case? Or that he would be involved in the trial?
A lot depends on his prognosis, right? So at this point, I could not say one way or the other. Whether Mr. Mello is going to continue, whether the district attorney is going to find another person, or whether I'm going to wind up doing it. I couldn't say it at this point. I'll only tell the court that I'm proceeding as if I'm going to be the trial attorney.
Why does it matter to you whether he's disqualified?
Well, he's a witness. We originally filed a motion for other reasons, and, they're readily apparent in the record that, I think it's just going to belabor the hearing to get into that. Part two of that, as that motion was pending for months and months, it became apparent that Mr. Mello is a witness in the case, and he's been communicating with the complainants on his cell phone exclusively, and he's definitely going to be a witness. We filed again papers to that effect. That's part two of the disqualification motion. That's probably the low-hanging fruit on it. The easy way out is that he's a witness. And
Okay. You want me to leave the hearing on for January 10?
at a minimum, we can address some of the other issues that are coming up in terms of discovery on that date, Your Honor. And if maybe, who knows? I don't know what his health situation is, Your Honor.
Well, we have 2 weeks in that, where very little is going to get done at the end of December. Does that give you enough time? Does that give the DA's office enough time to deal with the iCloud issue and the documents with regard to others in the DA's office?
I think I'm going to need 3 weeks anyway.
Yeah.
I think we'll have some business to attend to that day if you want, Your Honor. We'd like to just kind of keep the ball rolling.
We can leave it on. We can leave it on. We may have things to discuss about the Taint team's work, because if I enter this order today, we're going to have to figure out things like, has it been abided by? So we're going to need stuff from you to make sure that the Taint team process works, and there's a schedule for that.
Your Honor, if I can just backtrack for a second. I filed that motion under the optimistic assumption that it might be acted upon the last time. And I think there is a date in there for compliance in one aspect by Mr. Gradle that will have to be amended. I'm sorry. I take that back. I was thinking of the motion filed subject to the
Okay.
so I'll save
Yeah, I don't see any dates. All the dates that are in the Taint team protocol proposal all seem to be keyed off of the date that the order is signed.
Very good.
Okay? All right, you're on for the 10th. Anything else?
Yes, I'd like to be heard on the motion Mr. Gradle requested the last time that we were heard on the sidebar. I'd like to be heard on the sidebar again. And, I'm going to ask that conversation begin.
This is the request to vacate the court's order of September 27.
Right, and not when we propose it.
Okay. All right, I'll see you at the sidebar. Anything else today?
I think that's everything in common with what we cover here.
Okay, Mr. Bradle, anything else?
I'll say.
Okay, thank you.
We'll see you January 10th at 9 a.m.
All rise.